event today. Of course, as you know, the Israelis, Palestinians are in the midst of negotiations being mediated by Washington, and the 9-month timeline for the negotiations comes to a close at the end of April, April 29th. The Palestinians have stated clearly that if there's no progress in the negotiations by the end of that timeline, they will continue with what has been called the alternative strategy, a strategy of seeking statehood through involvement with international institutions and courts. And so this is a very timely event given those circumstances, and as we know, one of the institutions, international institutions, to which Palestine was welcomed as a state party in recent years was UNESCO. And so the topic of our conversation today is activating Palestine's UNESCO membership. And we're very happy to have Nidal Silman and Valentin Azarov with us here to talk about that. They wrote a fantastic paper on this topic. Nidal has more than 15 years of experience in international law, human rights, and international trade and development. He's worked as a legal advisor at the Negotiation Support Unit, which is a part of the PLO's side in the negotiations. And he's advised UNESCO and the Palestinian Authority on legislative reforms to protect Palestinian cultural heritage. Valentina was the program head of Human Rights and International Law program at Al-Quds Bard College, Al-Quds University, Palestine, where she is currently a lecturer on leave. So I will turn it over to them at this point for the presentation, and then we'll do Q&A later on. Thank you.
Well, thank you, Youssef. It's a pleasure to be here at the Palestine Center and to talk about such an important, I think, topic, which is how would Palestine activate its membership in UNESCO. I would like to thank the Palestine Center for hosting me and my colleague, Valentina. I also would like to thank Shabaka, which is the Palestinian Policy Network, for facilitating this event. About 2.5 years ago, Palestine gained full membership of UNESCO, but its representatives haven't yet made the best use of this new status, due in part to pressure from Israel and the United States. The UNESCO precedent is significant in the quest to fulfill Palestinian human rights and to apply relevant international law instruments to the case of Palestine. UNESCO membership is far more important than winning another vote at an international organization because it provides Palestine with significant practical advantages, including reasserting its sovereignty over its land and sea, and gaining and obliging third states to hold Israel accountable to its obligations. I will start by providing a quick overview of UNESCO and conventions that Palestine has ratified. I will also introduce two of the main conventions that were ratified by Palestine, namely the 1954 Convention for the Protection of Cultural Property During Armed Conflict and the 1972 Convention for the Protection of the World Cultural and Natural Heritage. My colleague Valentina will give more examples of how to operationalize the UNESCO membership after I finish my presentation. Now, this is the outline of the presentation. I will start by discussing why UNESCO is important, and then I will go, as I mentioned, through the obligations, the 1954 Convention, the 1972 Convention as well, and I will talk a little bit about the limited gains that Palestine has achieved despite the urgency of dealing with the situation. To save on time, I will go directly to this slide where it's important to recognize that UNESCO was a very important precedent. UNESCO is the first UN body that admitted the state of Palestine as a full member in the organization. By doing so, Palestine's status as a state was affirmed. In contrast, by the way, in 2012, when the UN voted to recognize Palestine as a state, it was a non-member state, so it wasn't really a full membership of the United Nations. This precedent will enable Palestine to join other international organizations and will open the door for its eligibility to ratify a list of international treaties to which the UN Secretary General is a depository. Equally important is the standing that this membership will afford Palestine in dealing with other third-party states and international actors to demand Israeli compliance with its international obligations. It is also important to note that almost immediately after Palestine was admitted, Israel announced the construction of 2,000 settlement homes, although we all know it doesn't really need an excuse to grab more Palestinian lands. The U.S. also announced suspended its financial contribution to the organization, citing domestic legislation that, by the way, is in contravention of its international binding legal obligations. It should also be noted that UNESCO has always been an important forum for upholding international law in relation to Israeli unlawful practices, including in Jerusalem. And we all remember what happened actually in 2010 when Israel attempted to include some of the cultural heritage sites located inside the West Bank on its national list. And UNESCO in 2010 condemned that and described it as a violation of international law, UNESCO Conventions, and also UN resolutions. Now, in addition to agreeing to UNESCO Constitution, which every member that joins the organization must agree to, Palestine has ratified 8 conventions and protocols since it joined the organization in 2011. All these instruments are legally binding on Palestine as one of the 195 members of the organization. And they include, of course, the 1954 Convention, which is, I believe, is especially important in the context of Palestine because it's under occupation, as well as the 1970 Convention on the means of prohibiting and preventing the illicit trade, export, and transfer of ownership of cultural property, the 1972 Convention on the protection of the world cultural and natural heritage, as well as 2001 Convention on protection of the underwater cultural heritage. And by the way, we all remember that a few weeks ago, a fisherman in Gaza discovered a very important piece, which right now we don't know where it is located, but this only provides, I think, an example of why it is important also to protect underwater cultural heritage. There's also the 2003 Convention for the Safeguarding of the Intangible Cultural Heritage and the 2005 Convention on the Protection and Promotion of the Diversity of Cultural Expressions. I will now introduce quickly one of the, I believe, important conventions to the Palestinian situation, which is the 1954 Convention for the Protection of Cultural Property in the Event of Armed Conflict, which, by the way, complements previous important international treaties that protect cultural property during armed conflict. In its preamble, the Convention emphasizes that damage to cultural property belonging to any people whatsoever means damage to the cultural heritage of all mankind. It includes a broad definition of what constitutes cultural property to cover movable, immovable property of great importance to heritage of every people, archaeological sites, of course, other objects, buildings, and quarters of all cities, like in the case of Jerusalem. The Convention, of course, prohibits theft, pillage, and misappropriation of or any act of vandalism against cultural property. It doesn't permit the occupier to take or export any cultural property from the occupied territory outside of the occupied territory, of course. And it limits the role, actually, of the occupier to supporting the competent national authorities of the occupied country in safeguarding and preserving its cultural property. It should also be noted that illicit trade or illegal trade in cultural property originating from an occupied territory is also prohibited by the 1970 Convention. Another important, I think, convention to the context of Palestine is also the 1972 World Cultural and Natural Heritage Convention. which, by the way, describes the deterioration or disappearance of any item of the cultural or natural heritage as constituting a harmful impoverishment of the heritage of all nations of the world. Therefore, the convention was concluded to establish an effective system of collective protection of the cultural and natural heritage of outstanding universal value, organized on a permanent basis and in accordance with modern scientific methods. State parties, according to the convention, are also obliged to identify and delineate cultural property in their territories. In addition, it recognizes the primary responsibility of each state to ensure the identification, protection, conservation, preservation, and transmission to future generations of cultural and natural heritage. It should be also noted that the convention established the UNESCO Committee for the Protection of the World Cultural and Natural Heritage, which in 2000 and actually in 1981 and 1982 inscribed the old city of Jerusalem and its walls on the list of World Heritage in danger and also on the list of World Heritage. So it's very important in the context of Palestine. Now, I want to discuss briefly here the limited gains despite the urgency of activating the membership of UNESCO. Utilization of UNESCO membership is still lacking, despite the continuous appropriation and destruction of Palestinian cultural heritage. Since 1967, Israel has damaged and destroyed historical, cultural, religious, and natural sites throughout the OPT. Immediately after the occupation, Israeli authorities, for example, razed the Moroccan Quarter in the Old City of Jerusalem and seized historical and religious buildings, such as the Palestine Archaeological Museum, which is now known as the Rockefeller Museum. An equally shocking example is the Simon Wiesenthal Center's construction of the Museum of Tolerance in West Jerusalem, which entailed excavations of ancient Mamilla cemetery in Jerusalem. Israel is also continuing with its plans to complete the construction of the wall, and we know that the International Court of Justice announced that plan to be illegal. However, some of the plans include completion of the construction of that wall in the vicinity of the village of Batir, threatening to destroy the natural landscape and historical terraces that are proposed for inclusion on the World Cultural and Natural Heritage List. Palestinian and Israeli sources estimate that between 1967 and 1992, about 200,000 artifacts were removed from the OPT annually, and another 120,000 were removed each year since 1995, which is a huge amount of artifacts. Despite the urgency to take prompt actions, Palestine has only made a few but tangible and concrete gains. It listed the first World Heritage Site, the Church of the Nativity in Bethlehem, in 2012 on the world list. However, 12 more sites remain on the tentative list, including the Batir terraces, which I discussed previously. Now, despite all the facts that I described, and it should be noted that Palestine's right to reparations is enshrined in international law. UNESCO and other international organizations have repeatedly condemned unlawful practices under Israel's occupation. States are responsible for their international wrongful acts and must make full reparations for the injury caused by the acts. The aim of the reparations must, as far as possible, wipe out all the consequences of the illegal act and re-establish the situation which would have existed if the act had not been committed. Reparations include restitution, compensation, and satisfaction under international law. It is also important for the Palestinians to raise the issue of reparations during the negotiations for Israel, and not just for damages to cultural properties, but I believe to all wrongful acts that committed by Israel. Because it's important to note that experiences all over the world, show that without reparations, no real conciliation can really happen between the two peoples. Now, it's important that Palestine did join UNESCO and did ratify 8 conventions, but statehood status and accession to international treaties can afford protection for rights, but they also entail obligations on the part of the state party. Thus, Palestine is required to modify its national legal system and relevant institutions in accordance with its obligations under UNESCO Constitution and the conventions it has ratified. There are at least 2 draft laws currently in place, and the idea behind those draft legislation is to modify what is currently in force in the OPT, which, as we know, the legal system in the West Bank and Gaza and Palestine is composed of Ottoman, British mandatory, Jordanian in the West Bank, and Egyptian in the Gaza Strip, and Palestinian Authority laws and Israeli military orders, which is really doesn't adequately protect Palestinian cultural heritage. The laws are fragmented, subject to Israel's whims, and do not really meet international standards. The role and mandates, by the way, also of the bodies officially responsible for protecting cultural heritage aren't really well defined. Therefore, it is important for the Palestinian authorities to pass the necessary legislation in line with international standards. The draft laws could, if enacted, significantly enhance Palestine's national legal framework, deter domestic violations, and further Palestine's standing in third countries and international institutions to contest, prevent, and take measures against unlawful Israeli conduct. Now, we have a few recommendations and conclusions. UNESCO offers a framework of control, protection, and cooperation with other states to protect cultural heritage. UNESCO, as a precedent, opens door for accession to international treaties, and Palestine should demonstrate its good faith acceptance of its obligations by bringing its domestic laws and institutions into compliance. Adequate legal protection of cultural heritage on the national level will support Palestine's efforts to reclaim possession of lost cultural properties. Local and international civil society organizations, we believe, should play a more active role in calling upon all parties to uphold international law. The issue of protecting cultural heritage must be separated from the politics of the peace process. I will leave it right here, and I will open the floor to my colleague Valentina to talk more about the operationalization of the UNESCO membership.
And again, thank you to Yusuf and Tamara for organizing this, and for all of you for coming. So my particular task, I hope to be successful in, is to look at how some of these obligations in international law, which is often subject to political discretion and political winds that are not in our favor, that's pretty clear, can be operationalized nevertheless by looking at third state responsibility in particular. And I'll unpack the concept of third state responsibility because I imagine not all of you are lawyers. So I'll try to do 2 things. One, start by looking at essentially how certain UNESCO law can be utilized to promote Palestinian heritage protection by, again, asking the question of how to make international law work and how to use, in particular, third state responsibility to bring about compliance not only by the third state, be it a European country or a North American country, mostly a law-abiding country. I'll get back to that. But also by Israel in this particular case. And Israel clearly is violating systematically many of its international obligations, including obligations under the instruments that Nidal just discussed, which of course overlap with many other human rights and international humanitarian law obligations. And secondly, I'll try to provide actual concrete examples of where UNESCO law operates within the legal order of specific states, and where we can, as civil society, use those internal obligations to bring about both protection for specific elements of Palestinian cultural heritage, as well as general compelling action by these third states vis-a-vis Israel and its illegal territorial regime in the West Bank and Gaza. So to start with a few, I guess, prefatory comments about the value of international law, which it seems is often overlooked to some extent. So this will be quite straightforward and familiar. International law is useful as a universal standard. And most often we use it in order to document violations, expose state behavior for not complying with those standards, and use it to raise public's awareness and to name and shame those states and whoever is complicit or involved in their wrongdoing. But that doesn't usually lead to enforcement or compliance. So how would enforcement or compliance potentially be brought about? Well, first, recognizing in this that international law is not real law. It's not the domestic law. It's not a traffic offense or a criminal offense. There's no enforcement body. There's no centralized authority that either determines what a violation is, let alone then sanctions those who commit them. So the question is how to overcome the political discretion which goes hand in hand with international law compliance and enforcement. And here's where, obviously, this political discretion is also common in international organizations, and we're talking here about UNESCO as the organization which is first and foremost entrusted with the enforcement and monitoring of compliance with the instruments that Nidal listed. So the question that I just raised has actually been looked into quite carefully over many years by the Mateen group that I work with, also at the moment being on leave from the university. Some of you may be familiar with Charles Chammas. For a number of decades, he's been working on the EU-Israel relations front, and the guidelines that came out in July 2013 excluding Israeli entities based or operating in settlements from any R&D, research and development funding from the EU. It's one of the measures that is based exactly on this doctrinal, conceptual understanding of international law and how it operates. So namely, this concept of third state responsibility in international law means a very simple thing. It means that any state cannot recognize, aid, or assist the wrongdoing of another state. But that obligation, as many obligations in international law, are very vague, non-specific, and again, discretionary and subject to political will. But the basis for operationalizing that obligation in an effective way, in a vigorous way, is found in many cases in the domestic or internal order of those third states. So in other words, international law has been incorporated into many third states, and again, law-abiding states in particular, the European Union and its member states as an important case in point. And those obligations, which include the general obligation to respect international law in the exercise of the European Union's powers, but also obligations within specific areas of internal law not to recognize certain unlawful conduct. And I'll come back to that example or to that principle when we look at the specific examples. Those obligations are enforceable because they're domestic and they're enforced within the system of the specific state or international actor. And the basis for their enforcement, as opposed to in international law being political, is the legal necessity of that state actor to ensure the integrity of their rule of law and to ensure certainty of their ability to apply certain law. It's bringing international law to the level of the traffic offense or the murder or whatever other civil wrong. So the EU guidelines, again, are the perfect example of this, because essentially what the European Union did is it realized that there was an oversight in the way that Israel was, in the way that EU-Israel cooperation in research and development was structured. In other words, there was no provision in EU law in that agreement or in the relevant financial instrument for this research and development program, 1.6 billion euros, to exclude entities that were operating or established in occupied territory under Israeli law. And because in Israel, it defines Israel as one thing, and the EU, and the rest of the world for that matter, defines it as another thing. But there was a very serious oversight in that agreement. It allowed Israel that leniency, that leeway to define entities established under Israeli law according to its understanding. And therefore, for some years, the EU ended up funding entities and settlements. I guess we can come back to that in the discussion. How does this translate in the UNESCO Law Framework? Two ways. Again, the general enforcement level concerning sovereignty rights and general non-recognition of Israel's illegal territorial regime. And there's the specific, which means protecting specific cultural property and bringing about accountability for Israeli wrongdoing. And I'll give my three examples according to those two categories, from the general to the specific, looking at first the example of UNESCO as a normative actor, so upholding certain international standards that translate into commitments in the third state's domestic legal order. I'll get into the details of that. Two, triggering enforcement by third states, looking specifically at the illicit transfer and restitution of artifacts under the convention that Nidal mentioned. So this would concern primarily museums and tour operators, and I'll get into that. And thirdly, the individual criminal responsibility aspect, which we're all familiar with, but we also know was subject to a lot of political discretion on the European front for some years now, where states had even changed their legislation as a result. But the reason for that goes back to my initial comments about when it's international law, then there is always discretion, even when the international law is part of domestic law. So universal jurisdiction law to prosecute war criminals from any state is still international law. It's still discretionary, even though it is part of the UK's, Spain's, or Belgium's laws. So the first example is basically the fact that UNESCO, as Nidal mentioned, is a lawmaking body to some extent. It makes the normative determinations with regards to which state or non-state actor violates its law. And it has a very rich body of law. The conventions that were listed here are a fraction of the actual richness. So in the resolutions, in the listings on the World Heritage List, in the potential for suspending aid to certain states, there are certain normative actions that the organization can take. And they're important on the international level when they happen, and they're obviously welcomed, but they also translate into understandings by the states that vote, that engage in these normative processes. So the states that make those assertions, contribute to those determinations, are also committed internally in their legal order not to recognize, again, under third state responsibility, and to refuse comity to Israel to the extent that Israeli law and Israeli institutional practices are the result of those unlawful acts that were condemned. What does that mean in practice? Well, it means that any structured or ad hoc engagement or exchange in the cultural, social, educational, scientific domains between specific states or between international organizations in Israel would be subject to that standard as well, or to that determination. In other words, if Israel is not complying with certain legal obligations, those states cannot allow that engagement to be implemented on the basis of those unlawful practices, on the basis of unlawful Israeli laws, be it the fact that the Israeli Antiquities Authority or the national parks or tour operators, which we'll get to, are operating in occupied territory as if it is part of Israel. That is, those are specific elements of the general illegal regime. It also entails certain consequences for Israel's good standing in those international organizations. And that's a more arduous process of getting that activated, but there are very, very good stakes there. And of course, again, the reassertion of sovereignty, especially in the case of Gaza, where up to 24 nautical miles could be obtained as territorial waters, could have certain potential. I mean, again, the definition of territorial waters, I think Nidal could probably say more about that and the processes that were and are being undertaken by the NSU, but it has its political limitations as well. The second example, as I said, going from the more general, fluffy stuff to some more specifics. Second example is the example, my favorite one, the example of museums and tour operators. Essentially, this is where third states can really get themselves into trouble by allowing artifacts to enter and freely circulate on their market, be it with museums, art dealers, auction houses, private individuals, whoever it is, because that concerns certain legislation that most states have, and certainly all European countries have, that pertain to the legality of the way certain property was obtained in another country. Doesn't matter what the property is, but when the property has importance on the international level, it matters even more. So essentially what I'm listing out here is the process by which the relevant national authority in a specific country, it's like the UK, its relevant criminal law enforcement authority would be addressed by Palestinian civil society, an individual, whoever it is, with the documentation that would show that either Israeli museums or art dealers who are transferring artifacts to the UK have potentially, this is where you raise suspicion rather than conclusively determine something, obtain those artifacts from occupied territory. Why? Because there is a rampant practice, systematic practice of unlawful transfer, because a lot of these artifacts are held by private individuals in Israel and have been circulating beyond Israel by private individuals, and because generally, even if, let's say, a museum in the UK says, well, we got this from Israel, Israeli authorities have confirmed that this comes from Israel, the way Israel defines itself is very different than the way the UK or the EU would define Israel. So if Israel says it's Israel, it doesn't mean it's Israel. So there's very serious suspicion there to be raised in particular countries that have established relations, auction houses or museums, with the Israel Museum or any other dealers. And here there's quite a bit of fact-finding to still be done. And if that suspicion is raised adequately, in the best case scenario, the national authority in the UK would have to clear any dealer or museum who brings in anything from Israel. Why? Because the suspicion is up and it needs to be reversed to make sure that that is not an artifact out of the millions that have been pillaged. Of course, in parallel to that, there's UNESCO's Restitution Committee, but again, there things are slightly more political, and there are, stories to be told about how successful or not those processes have been. The tour operators example, very briefly, is based on the fact that Israeli tour operators and tourist sites are based in the West Bank, again, existing there and registered and administered by Israeli law as if they were inside Israel. And many tour agencies, at least from my knowledge in the EU, because there's some work being done on that at the moment that I'm involved in, are advertising. There are two things that happen here, and probably more than these two things, but these are good examples. One, they're advertising their itineraries to include the West Bank as if they're still in Israel. Bethlehem, Qumran, Jericho, all these destinations are misrepresented, and that's an issue of consumer protection law. In fact, the European Union has harmonized the law that protects consumers from deceptively being told misrepresented the destination of the itinerary. A package holiday must have clearly stated destination. So there's actually this pretty incredible project that has been looking at 120 different operators across 7 EU countries, and the inconsistencies are incredible. The maps are incredible. The itineraries are completely all over the place. So, but those are the kind of interventions where international law can actually be enforced effectively from within a legal order. So I will quickly mention the individual criminal accountability bit, which Nidal, I think, alluded to in 2 instruments that Palestine is now a state party to. There are references to individual criminal responsibility. It's basically like the war crimes references in the Geneva Conventions. Very similar, but specific to cultural heritage protection. For excavations, for destruction, and for removal of artifacts. So any individuals, political or military officials involved in that, or even private individuals, we have the Israeli Antiquities Authority brings in, and this is a really interesting area to look at, fact-wise, who is the Israeli Antiquities Authority? What universities, other private actors from around the world are coming to dig with them? Because I've seen these brochures. Come and dig with us in this place. So that would entail, to a certain extent, potential complicity, at least on a certain level. So, of course, the prosecutions, as we know, have not been very successful. We've been doing this. I did this. I worked with Al-Haq for 2 years, and the results were not favorable. And of course, some have even blamed the Palestinian civil society involved in those efforts for having caused the law to be changed in at least 3 jurisdictions in the EU. So now the political forces are even more involved in opening any of these war crimes investigations. But the question of prosecution is not the only one when it comes to individual criminal accountability, because, and this came up more recently in settler violence discussions, the other avenue, which is yet to be explored fully, is again an issue of good standing, but here it's individual good standing. And that good standing, when it comes to involvement in war crimes, is translated into travel restrictions. So here we're not talking about just trial, but also certain risk-aversive measures that European countries and potentially the EU on the general level could take vis-a-vis certain individuals by essentially blacklisting them or restricting their travel. That's a pretty standard thing that states do when you enter the country. You have to tick a box to say, I haven't been involved in any terrorist activity. I haven't been involved in any international criminal law violations. And of course, the good staff officer for archaeology should be at the top of that list. I think I'm going to repeat some of the things that Nidal said here, but very quickly, I think the first 2 points in terms of takeaways from what I've said are my highlights. One, that we need to look at the normative regulatory order of the state actor. Okay, I have time. At the state or non-state actor, international organizations in particular, that we're trying to compel to comply with international law, because it's their order and their commitments, their voluntary commitments, which are the basis for enforcement, for their necessity to comply. And so, you know, having civil society for many years say, you know, this must be done because it's the law, or this state should comply with the law, this state should stop selling arms. Well, those are potential objectives, but the way to reach them would be not to invoke international law as the sole basis for the obligation, but to actually look for the basis for the obligation in the national law. And I think the museums and tour operators example really brings that to life. And of course, the value of the technical approach, which is one of the same thing. The way not to politicize international law is to show that it's part of the very rule of law, of the actor that we're looking to influence, that we're looking to bring on our side. Just to reiterate, we do need a more coherent and comprehensive approach to international law engagement, the international law strategy. And again, I think Nidal could say more about that in terms of what the NSU has done, and I know there's a very elaborate and thorough file that's in the archives, but it's never really been operationalized. And the other thing that I think I was saying in between over and over is the capacity that we need for fact-finding and documentation. And the way that we need to be smart about it is, if we get the UK criminal law authority to be suspicious of any artifacts coming from Israel, generally, anyone dealing in those artifacts or exhibiting them, and we can also get them for the purpose of for the purpose of certainty and lack of risk in enforcing UK law, to demand, as a pretty standard procedure, to demand that Israel cooperate through law enforcement and provide the UK or any other country with information about the artifacts. That information no one has. I mean, in my discussions with the Ministry of Antiquities, there is no per se registry or register for Palestinian cultural heritage that has been illicitly transferred. So that information can be gained through the third state approach as well. I think I'll end there. Thank you.